Ladies and gentlemen, it's time for the opening lecture. Time is limited. So this moment is special, so we might be short in seats. We have some seats left there for VIPs. But, you know, you can stand perhaps a little bit if you don't find a seat. That's not an issue for young people. Let me say a word of our special guest, Dame Higgins. I will present her, and then we'll leave her the floor. Dame Rosalyn Higgins was born from 2006 to 2009, the president of the International Court of Justice and a member of the ICJ from 1995 until 2009. A personal note to say that the first time I appeared before the ICJ was before a court presided by Rosalyn, and I remember vividly that she was very kind, and it helped me a lot. She was the first woman elected to the court and the first female president. She had studied at Cambridge University and indeed was a classmate of Isashi Owada, a great judge as well. Between her 2 degrees in Cambridge University, Rosalyn Higgins spent time on a scholarship program at the United Nations, in which organization she developed a lifelong interest. After completing her studies at Cambridge, she went to Yale to pursue a GSD, which culminated in her first book, The Development of International Law Through the Political Organs of the United Nations. Rosalyn Higgins returned to the United Kingdom as the staff specialist in international law at the Royal Institute of International Affairs. They are giving lectures, writing articles in the first 2 volumes of her 4-volume work on UN peacekeeping that I think a lot of you know. She became professor at the University of Kent and then at London School of Economics. She had visiting professorship at Yale and Stanford. In 1985, while still teaching, she became a member of the UN Committee on Human Rights, operating under the International Covenant on Civil and Political Rights, and continued as a member until her election to the International Court of Justice in 1995. She was an active member of the court, often selected to be on drafting committees, and when president, devoted much energy to improving the court's methods of working. Judge Higgins is still active as a bencher of the Inner Temple. When she retired from the court in 2009, she became president of the British Institute of International and Comparative Law, was legal advisor to the Chilcot Committee, which reported on the British involvement in Iraq in 2001-2009, and added to her many publications by producing the 2 volumes Oppenheim's United Nations Law. Her other major works include Problems and Process and the 2 volumes Themes and Theories, and I should say also her lecture at the Academy, of course, that you will find in the marvelous collection of the Recueil des Cours of the Academy. Thank you very much, Dame Higgins, to be there to deliver the opening lecture of the centenary session. Dame Higgins, the floor is yours.
Excellencies, Secretary General, dear colleagues and friends of whom I see so many, ladies and gentlemen. It is an extraordinary thing that a teaching institution, 100 years after its inception, attracts support and appreciation not only from the world of scholarship, but from the world of diplomacy, politics, and the judiciary. The very presence of such a gathering this morning is a tremendous testimonial to what the Hague Academy has come to mean to all of us here. So thank you all so much for being here on this occasion, which is indeed commemorative, but it also marks the beginning of the 100th session of courses. And I think you will understand that after these introductory words, I address my remarks primarily to the students beginning their 3 weeks in The Hague. So it's a delight for me to welcome you all to the opening of the 2023 Public International Law session of the Hague Academy of International Law. These sessions are not for beginners. To be admitted to the Hague Academy sessions, you have to have shown that you already have a real familiarity with the field of international law, and that you have both achievements and potential that make you stand out from other applicants. So congratulations on making it here to The Hague, where you will learn much and you'll establish friendships that will last a lifetime and have a thoroughly enjoyable time. You'll already have seen that in addition to the lectures, you'll benefit from seminars, cultural events, social gatherings, and of course, the beach at Scheveningen, if only the sun will continue to shine. And I think there's a good chance of that for a while. What brought you here? Each one of you will have had her or his own reason for wanting to attend the 2023 summer course. Perhaps you wanted to listen to and meet the very distinguished lecturers gathered here over the course of these 3 weeks. Professor Silianos will be giving the general course over the entirety of your period of stay. The other distinguished lecturers will each traverse their chosen subject over the course of a week. And your directors of studies, also here throughout your 3-week stay, will direct study sessions and perhaps a handful of you for the examinations of the coveted Hague Diploma in International Law. Or perhaps it's the subjects being covered by these leading personages that made you want to be here this summer. Disarmament, soft law, armed conflicts, the relationship between the international and the municipal, post-colonialism and law. These offer an intriguing range of topics. But perhaps you had not previously realized that you're attending a very special summer course because it is the 100th year of courses of the Hague Academy of International Law. And that being so, I thought I would talk to you not about a specific topic of international law, but about how the Hague Academy works, what goes on behind the scenes to make this the preeminent advanced course in our field, how the subjects are chosen by those lecturing and teaching reflect or are a mirror on the development, broadening, and deepening of our field. How can it be that an organization so old and so venerable is not dated, fusty, overtaken by newer, more contemporary bodies? How can the Hague Academy still be primus inter partes? What I hope to do this morning is to explain how the Academy, and in association with it, of course, the Curatorium, work together, ensuring that the courses remain highly important to students and lecturers alike, to survey the international law topics chosen over the last 100 years. Yes, I have gone back over all of the 100 years. And to suggest how and why these choices came about. And importantly, I think, to provide you with footnotes to the written version of this lecture, references exactly to show you where you will find the lectures given over the years on subject matter that may be of special interest to you. And I hope that these subject matter collections will be a huge use and interest to you, saving you hours of digging around. And I wish to say straight away that the Academy has been extremely amenable in my unusual request that these footnotes through the 100 years on particular topics that may specially interest any one of you should be available at the end of this lecture online, and I thank them for their flexibility. Behind the Hague Academy of International Law lies, as you heard this morning, the Curatorium, a body of leading international lawyers that is characterized not only by their eminence, but also by their diversity, so far as nationality, race, and gender are concerned. And as you heard, the current president is Professor Yves Daudet, formerly the Secretary General of the Hague Academy, so what long service he has given, who knows the Academy inside out. Today and for the past 6 years, Professor Jean-Marc Touvenin, who you heard this morning, has been our Secretary General. And I'll briefly mention the members of the Curatorium other than its president, Judge Mohamed Benouna, Morocco, Professor Katharina Berle-Wolke, Germany, Professor Hannah Buxbaum, United States, Judge Hilary Charlesworth, Australia, Professor Cordero Moss, Italy, Professor Fernandez Arroyo, Argentina, Judge Maria Teresa Infante Caffi of Chile, Professor Bingbing Jia, China, Professor Maurice Kamto of Cameroon, Professor Moise Mugenge of Senegal, Professor Dimchid Momtaz of Iran, Professor Nishitani of Japan, Professor Nico Schrijver of the Netherlands, Professor Sicilianos of Greece, Judge Peter Tomka of Slovakia, and Professor Tullio Treves of Italy. Many of these personages have themselves in the past given lectures in the Hague Academy courses. And of course, this summer you'll be able to hear the general course being given by Curatorium member Professor Sicilianos, former President of the European Court of Human Rights and presently Dean of the Law Faculty of the University of Athens. So you can see that professors can become judges, judges can return to lives in academia, judges write articles and books while still on the bench, and between them, the members of the Curatorium come from the widest range of countries and cultures and are highly knowledgeable across a huge range of international law specialities. And they will know the exciting and upcoming international lawyers, both in their own countries and across the globe in their own special areas of international law. And in turn, they're recipients of many suggestions about potential lecturers. So it's no surprise that for this 100th summer course, you'll hear 5 men and 3 women from 8 countries on a variety of topics. How are the topics that you find awaiting you actually selected? Lectures delivered at an academy course are not just any old lectures. They're expected to be of the very highest quality, and the invited lecturer, who may well be a professor, a practitioner, even a judge, must be given time to prepare this magnum opus. So usually, an invitation to deliver a lecture goes out to 2 and 3 years ahead of the date scheduled, and the recipient, being extremely busy in his or her life as an academic practitioner, often a mixture of both, or judge, finds this generous allotted preparation time alarmingly short. The curatorium is very involved in the Hague Academy courses. It's here that discussions are held on which persons, already very senior or upcoming as lecturers, should be invited with a good lead time to prepare. The curatorium does not itself select, initially at least, the topic on which the forthcoming lecture should be given. So when you see in the records occasional clustering of topics in a given year, that is, in fact, entirely coincidental. What happens is that the invited lecturer is asked to suggest 3 topics on which he or she could teach, and the curatorium then makes the selection between them. I gave in 1982 a week's course of lectures on the taking of property in international law. I have to confess that I have no recollection whatever of the 2 alternatives I suggested, but I'm glad they were not selected by the curatorium. Of course, a general course, the 3-week-long lecture series, is a general course. The curatorium decides who to invite, but then is not at all involved in what the lecturer chooses to cover. The problem for the person giving the general course is to find 3 weeks of interesting ideas, avoiding mere repetition of what has gone before in previous such courses. Involving the judges of the International Court is not only interesting for students, but part of what keeps the Academy up to date. And there are various ways of doing this. A judge can be invited to give an inaugural lecture at the beginning of a session, or rather more unusually, to give a week's lecture course or even the general course. And each year, a judge is invited to give an afternoon lecture, not strictly speaking part of the academy course, but rather optional for students. And this year, you'll have, in that context, the opportunity to hear the Lebanese judge of the International Court of Justice. Part of what makes the Hague Academy course so rewarding is the existence of the Centre for Research and Studies, led by a French and English language professor. They constantly supplement what the students get from the lectures themselves, with seminars, discussions, personal contacts, excursions, and more. And as you heard this morning, if a student wishes to prepare for the diploma, then the research centre leaders will help them. And this year you've 2 exceptional such directors, Professor Philippa Webb of King's College London and Professor Lucie Delaby of the Université de Picardie, Jules Verne. Part of the question and the answer to the question, 100 sessions on, as to how the Academy can be so up-to-date and relevant, lies in the fact there have been constant innovations. Successive Secretaries General, including the vigorous and imaginative current Secretary General, Professor Touvenin, have led these important new ventures. For example, during the worst of the COVID pandemic, normal in-person courses could not be held. You may all imagine the work involved in ensuring that there were still courses available online. And even before the pandemic, from 2019, there was introduced winter courses of the Hague Academy. And you heard the large numbers attending this summer, and numbers for those courses are usually around 220 to 320 persons, very popular also. And as you also know, the lectures are all published in the venerable Recueil de Cours. Occasionally, the Academy will agree with a lecturer that a course may appear as a book outside of and in addition to the series. So my general course in 1991 was separately published as Problems and Process. And all of this innovation has been supplemented by the recent pocketbook publications that Professor Touvenin spoke of this morning. So I come to the question of a mirror of international law. We've seen a little of the enormous operation that lies behind 100 years of Hague Academy courses, seminars, conferences, and the high appreciation in which they continue to be held. But how should we be able to see if the title of my talk is warranted? Does what the Hague Academy has provided for 100 years constitute a mirror on international law? It seems to me that in such a mirror one would expect to see the classical topics that form the leading textbooks of international law: the nature of international law, the sources of international law, treaties, jurisdiction, the use of force, state responsibility, dispute settlement. But then a mirror on international law would not be limited to these classical topics, but would also show the responses to the great contemporary problems of the day, to major political and legal events, developments that assess new and difficult issues going beyond our classical headings. And for the very large part, that is indeed what each of us may find within this treasure house of Hague Academy lectures. If we begin with the classical headings that one finds in the major textbooks, then the nature and concept of international law is well covered, both in general courses and in the one-week courses. The initial definition of international law as the law governing relations between states has for long years now been acknowledged as needing expansion, in large part because of the existence and burgeoning of international organizations. For the moment, it suffices to say that our lecturers have for many years now perceived international law as the law governing relations between states, or between states and international organizations, or between international organizations. But beyond that, do the Hague lectures illuminate what exactly this law between the actors just described is? Is it the rules that govern these relationships? And that leads inevitably into the issue of theory. As I went through the listing of all the courses that have been given in the last 100 years in preparation for this talk, I discovered to my pleasure that theory has not been an ignored subject. How, as an international lawyer, you wrestle with the most contested issues of the day depends on the theoretical model of international law that is your starting framework. Of course, if, like some eminent jurists, you insist that all of this is unnecessary, that all is needed is to be sensibly pragmatic and apply the governing rules impartially to arrive at the correct solution, well, like it or not, you have selected your own model of legal theory. Pragmatism, finding the correct rule, applying it impartially, these notions presuppose that international law is a set of rules which can be found without reference to the past, to context, or to desired outcomes. To those who proudly wore the badge of pragmatism, international law has nothing to do with the promotion of values. It's about knowing the rules. But another starting point, readily acknowledged as a theoretical model, rejects the idea of international law as rules to be neutrally applied. International law is composed mostly of norms, and these are sometimes competing. So Article 2.4 of the UN Charter prohibits the use of force against a state, but Article 51 permits force in pursuit of self-defense. Jurisdiction, that is to say, competence over persons and events, is mostly territorial, but extraterritorial jurisdiction is permitted in a variety of circumstances. There's no correct rule to be found. There are rather choices to be made between possible applicable norms, choices which will depend upon a contextual reading of precedent and a sensitivity to the values that international law seeks to promote. Now, am I saying there's no such thing as a rule? No, certainly there are rules. International law is largely composed of norms, the applicability of which to the facts at hand has to be determined by the decision maker. But rules countenance no debate. So there are at the moment 15 members of the Security Council. Each member of the General Assembly, large or small, powerful or not, has an equal unweighted vote in that organ. These are rules, not past practice, context, or policy preferences to promote outcomes. Of course, this is only part of the story. Within it, you find other elements, the place and reality of soft law, which is one of your lecture topics, for example. So I now come to the classic topics. Of course, the fact that the classic textbook themes are well represented in Hague lectures does not mean that the same ground has been trodden and retrodden, because they've occurred through the years important developments within those themes. The question of jurisdiction, for example, who has what competence over whom and what, is indeed present in our mirror. But it's interesting to contrast what is said and written in 1948 on a given subject with what was said and written by a lecture you'll find in my gathered footnotes on the very same subject in 2020. By 2020, the question of extraterritorial jurisdiction was no longer an interesting theoretical matter. It had become an important issue. And if the elements forming the backbone of the law of state responsibility have remained constant, the developments within that subject have been simply enormous. And I hope that with the assistance of the footnote references I've mentioned, you'll find it interesting to compare what Hague Academy lectures have had to say in 1939, 1955, 1984, the lecturer of that year being a distinguished East German Marxist, and 2018. And of course, the International Law Commission presented the General Assembly with its vast and meticulous articles on state responsibility. This venture was worked on by different rapporteurs over the years and impressively and meticulously brought to fruition by its lamented last rapporteur, James Crawford. The work is of such quality that it is today widely cited and relied on, though it's never become a treaty, but remains at the formal level a report of the International Law Commission. And developments within a subject often emanate from more than one source. For example, James Crawford held back the ILC work on assurances and guarantees of non-repetition, which was an issue pending before the court within the Lagrange case. After the court gave judgment in 2001, the ILC then and only then proceeded to finalize its articles on that subject. Treaties. International law, as it refers to treaties, is another example of a classical topic included in every textbook, but the contents of which has greatly developed through time. Here too, a great international treaty, the Law of Treaties 1969, has influenced the direction and manner of developments within the subject. And the lectures given by those persons invited by the Academy to teach this topic can certainly be described as a mirror on these developments. The 1969 Convention is today widely regarded as reflecting customary international law, and so its applicability is not limited to the parties to that convention, and this has been affirmed by the International Court of Justice on several occasions. The huge treaty-making practice of international organizations, with all the implications for depositories, reservations, and so forth, has been reflected in topics addressed in the Hague lectures. The range of topics mirror the development within this larger area of treaties. And moving forward from the 1930s, we see how the topics selected by some of the great names in our field mirror international developments. Travaux préparatoires, treaty interpretation, systems and functions of treaties, effect of war on treaties, l'extinction et la suspension des traités, interpretation of treaties, after the Vienna Convention, fundamental change of circumstances, a topic that was later to form a major component in the Gabčíkovo-Nažimáros case before the course, and of course reservations. And I hope you'll find useful the references over 100 years of Academy lectures that I've prepared on these elements within the law of treaties. As for the use of force, most commentators who know little of our subject seem to think that is what the subject is all about. It's only about, they think, the use of force. And regrettable outbursts of international violence confirm for them the total inefficiency of international law. Those of us who've studied international law know the breadth and depth of the subject. Certainly, the use of force remains a necessary chapter in every textbook. It does seem to me that the reality of the topic's place in the great spectrum of the law of nations is mirrored in the Hague Academy lectures, in that aspects and indeed overall surveys appear from time to time in lectures, but do not dominate the choice of subjects. It's a huge field with some long-standing issues that remain unresolved and other legal issues that have come to the fore in recent events and because of what has been said in recent international court judgments. Is Article 51 of the Charter but an exception to Article 2.4, or is it a reserved and equal right? Will there ever be agreement on the scope and meaning of anticipatory self-defense? Do we now have a clear understanding of the claim to humanitarian intervention? May the ruling authority in an occupied territory use force against the occupying power, and is it precluded in so doing from the use of force against civilians? And a thought put in the front of my mind by the Russian invasion of Ukraine, but on which I have heard absolutely nothing said by governments or scholars, is the notion of collective self-defense under the Charter dead, having been drowned by Article 5 of the NATO Treaty. You, no doubt, have many, many more examples of use of force uncertainties that could make interesting Hague lectures. A word on the law of the sea. The law of the sea is a prime example of a topic that's become an essential component of international law since the time of Grotius and before, but has so much developed and changed since the 1950s that it continues to attract the interest of scholars and practitioners alike. You all know that the UN held a first conference on the subject, resulting in 4 treaties concluded in 1958, which entered into force on various dates in the first half of the 1960s. And among these was the Convention on the Continental Shelf, which essentially confirmed the proclamation made in 1945 by President Truman as to the status of the shelf and the entitlement of the coastal state, and also concluded with the Convention on the Territorial Sea and Contiguous Zone, the Convention on Fishing and Conservation of the Living Resources of the High Seas. The negotiation of these texts involved much effort and time, and they were generally regarded as successful. But inevitably, some important questions had been left open, including the critical issue of the width of the territorial sea. A second UN conference failed to resolve these outstanding issues, but Malta is to be credited with possessing another attempt to resolve them. From 1973 until 1982, so-called UNCLOS 3 proceeded to negotiate these issues, working on the basis of consensus. And it's hard to exaggerate what the nations of the world achieved during this period, both because of the prodigious amount of effort and expense involved and the deeply divided political situation in which today we find ourselves, I think we shall not see again such efforts at law clarification and development. So wide and so interesting is the subject matter that it's really not surprising that there has been, right until the present time, much litigation and writing and lecturing on the law of the sea matters. The great part of the legal provisions have come to be regarded as having the status of customary international law, and this has been confirmed on several occasions by the International Court. And further, states which did not ratify the Convention have not infrequently acted and introduced legislation reflecting the provisions in the Convention. And in 1996, the UN Tribunal for the Law of the Sea, ITLOS, was inaugurated, and those giving lectures to our academy have not failed to make their own contributions to these developments. The International Court of Justice has had occasion to reflect these developments in its judgments, but very importantly, it has itself developed an important and distinct strand in maritime law, namely the delimitation of territorial seas between opposite and adjacent neighbours. In early cases, the International Court had emphasised that the methodology it would choose should reflect the objective of reaching an equitable result. But in a later series of cases, the court essentially moved away from this somewhat subjective methodology to a more objective three-stage methodology. And in recent cases, it sought to square the circle by describing the objective methods to reach an equitable result. And this methodology is well described in the case concerning Romania against Ukraine, the maritime delimitation in the Black Sea. I now say a word on the issue of major developments. Of course, sometimes it's great events that have inspired the topics selected by Hague Academy lecturers. So it's not surprising that we find this true of the Hague Peace Conferences, the 1928 Pact of Paris, the Bretton Woods Arrangements, the Geneva Conventions of 1949, the advent of what was eventually to become the European Union, the 1969 Vienna Convention on the Law of Treaties, the Helsinki Final Act, that has appeared very regularly in the lectures, and the 1982 Convention on the Law of the Sea. These were all momentous events in international law as well as in politics, and their importance has been mirrored in the work of the Hague Academy, and some of these lectures have become truly magisterial. As we've seen, international law is a marvelously diverse subject, comprising still essential classic themes that develop in their context over the years, as well as truly new subject matter. There are two topics that together form by far the most popular and frequent themes for Hague Academy lectures, each reflecting major new developments in our subject since World War II. The first of these is international courts, and the second, international organizations. In 1945, the new International Court of Justice, successor to the Permanent Court of International Justice, stood alone as an international court. Before long, it was joined by specialist regional courts in the field of human rights, including the European Court of Human Rights and the Inter-American Court of Human Rights. And the UN brought to fruition several multilateral treaties on human rights, including those relating to the International Covenant on Civil and Political Rights, which envisaged a quasi-judicial role for their monitoring bodies under their relevant optional protocols, respective optional protocols. And there then burst upon the scene a cluster of ad hoc international criminal tribunals. And I recall wearing my professorial hat when it was very hard to get a student to do a term paper on anything other than international criminal law. And then in 1998, the Statute of the International Criminal Court was adopted, and it entered into force in 2002. And this, as you know, has given rise to many challenging and contentious issues at both legal and political levels. So you'll find, dear students, lectures by the great names in an ever-expanding field of international organizations, explaining not only their structure and work, but the huge range of legal issues they've given rise to. What a privilege to read Wilfried Jenks, Philip Jessup, Oscar Schachter, among so many others, on the diverse and engrossing problems that you will find awaiting you as you enter this rich field of international law. Immunities of international organizations, coordination, their role in dispute settlement, legislative activities, secretariats, it's all there in the Hague lectures and much, much more. The explosion of international courts and tribunals in this last half century has meant there's been a parallel explosion in the development of international law in this topic, and the Hague Academy lectures have both reflected that development and been part of it, because so many of the lecturers have been involved one way or another in this exploding judicial world. The ICJ, the only standing international court in 1945, and with a universal subject matter jurisdiction, was within a few years joined by a cluster of regional courts dealing with human rights disputes and claims: the European Court of Human Rights, the Inter-American Court under the American Convention, the African Court under the African Charter. These are permanent courts, albeit with a very specific jurisdiction. And in the last quarter century, we've seen the emergence of ad hoc tribunals with specified subject matter, temporal and territorial jurisdiction, and always intended to be wound up when their work was complete. When the ICTY and the ICTR were established in 1993 and 1994 by the Security Council, there was much legal controversy about the authority of the Security Council so to act under the Charter. These issues today are largely resolved. Their work is essentially completed, with many important judgments having been rendered. As their judicial work developed, more and more legal issues faced the judges, who bore great responsibility for developing international criminal law. And in 2002, they entered into operation the International Criminal Court, which, as you know, is a permanent institution not under the UN, but closely related to it, both as a matter of its statute provisions and of politics. and we've also seen special courts and tribunals, such as the Special Court for Sierra Leone, the Extraordinary Chambers in the courts of Cambodia, the Special Tribunal for Lebanon, and the Kosovo Specialist Chambers. There has been and continues to be a huge literature on these courts and tribunals, and much of these developments have been mirrored and further developed in the contributions made by different lecturers given in their courses in the Hague Academy. Of course, the topics relating to courts are endless. And of course, there are also truly new topics. Science and technology have led to topics that at the time were not reflective of great world events, nor were they developed classical themes, but were truly new. I'll just mention here air law and space law, and while there's no time to talk further in these areas, you will find all the lectures on these topics neglected. So in conclusion, I've tried to give some sense of how the quality of Hague Academy lectures and the subject matter chosen has, among other things, reflected international law in all its breadth. But you shouldn't think you can forego a wider portfolio to read, because in some areas it cannot in all honesty be claimed that the Hague lectures mirror international law. Some topics of great importance have emerged through decisions and developments in the UN, others through decisions and opinions of the International Court and other courts, but not all of these have attracted contributions by Hague Academy lecturers. Going through the last 100 years of topics, I was surprised at how little there is on the extremely important topics of self-determination and of peacekeeping, which is a topic of huge importance. So I do welcome you here. I urge you to read widely books, lectures, judgments from just as many sources as you can lay your hands on. It's been a tremendous honor for me to be asked to give this inaugural lecture, and I wish you all a wonderful 3 weeks.